Well, the media is leading with news about the media being attacked in Egypt. We'll talk about that. That's not my leading story. So that's what we're going to hear all day and night, how the media is being abused in Egypt. It's amazing. It's amazing how these things are crystallized for the media when it's the media that's being attacked. More on that in a moment. Ladies and gentlemen, the Obama administration has been held in contempt of court by a federal judge. What that means is there was a court ruling and the Obama administration intentionally violated it. What that means is the Obama administration intentionally defied a federal judge. And other than a story in Bloomberg, it's not really being covered much anywhere at a national level. This is becoming a pattern now. This government defying the Constitution and the media essentially yawning. Now, I want to focus on our government for a moment. I want to focus on our society for a moment before we start lecturing everybody else. When I say that we lived in a soft tyranny, when I say that we have a president who is out of control, when I say we have a bureaucracy out of control, this confirms it. This isn't even about health care. This is about what occurred over the summer in the Gulf of Mexico. Bloomberg, the Obama administration, acted in contempt by continuing its deep-water drilling moratorium after the policy was struck down, said U.S. District Court Martin Feldman in New Orleans. Interior Department regulators acted with determined disregard by lifting and reinstituting a series of policy changes that restricted offshore drilling. Each step the government took following the court's imposition of a preliminary injunction showcases its defiance. He issued a preliminary injunction against the government. And what did the Interior Secretary Salazar do? He put out another phony order pretending to comply with what the judge said. Now, this is the same Salazar who submitted evidence with the Justice Department lawyers to this court, which was false evidence. That is, remember those experts who were said to have signed off on a statement that drilling should not occur? And the overwhelming majority of them said, wait a minute, we didn't agree to that. We have an utterly lawless administration that will do anything to advance its cause, including lie to a federal judge, including defy a federal judge. If any one of you did that, you'd be sitting in prison today. Any of you. The judge went on. Such dismissive conduct, viewed in tandem with the reimposition of a second blanket and substantively identical moratorium, and in light of the national importance of this case, provide this court with clear and convincing evidence of the government's contempt. That is, Barack Obama, you are held in contempt. Now, I believe your administration is contemptible, but now you're officially contemptible. Feldman overturned the initial ban as overly broad on June 22 after the offshore drilling industry and Gulf Coast political and business leaders challenged it. A Justice Department spokesman, Win Hornbuckle, said the government is reviewing yesterday's ruling. He declined to comment further. We listen to this. Listen to this, and official Washington is yawning. Federal law enforcement is yawning. Why aren't the reporters lined up at the United States Justice Department demanding that the Attorney General of the United States explain himself? Why aren't they lining up at the Interior Department? I've worked at both these departments under Ronald Reagan. Why aren't they lining up at the Interior Department and demanding that Secretary Salazar explain himself? Where's the White House press corps? The administration they're covering, the White House they're covering, was just held in contempt of court. This won't be covered on a single damn network news broadcast. I guarantee it. Meanwhile, in Florida, another judge has ruled this government out of order. Another judge has ruled that this government is attempting to do something it doesn't have the power to do. The Justice Department was more than happy to send government lawyers into that courtroom to defend against the litigation of 26 states. By the way, let me pause and put a footnote in here. We actually have 28 states that oppose this law, including Oklahoma and Virginia that went on their own for different reasons. We have the House of Representatives that voted to repeal this law. We have 47 Republican senators out of 100 senators who voted to repeal this law. So 28 states, the House of Representatives, almost a majority of the Senate, and they don't give a damn. They say you want this. End footnote. Now, let's go back to the story. They send their lawyers into this courtroom. They file briefs. They argue against the plaintiffs, the states. And they lose. I checked today. Even though this ruling was ordered on Monday, the federal government, that is the Obama administration, still has not filed a motion to stay the lower court's ruling with the circuit court. It still refuses to comply with the federal judge's ruling, which is the law of the land, and it refuses to file a motion in the circuit court to try and stay the judge's motion. Instead, it's just defying a court. Now, one of you states, one of you litigants, plaintiffs, need to go back to this judge and let him know that the federal government has not ceased. It will not desist. It is trying to enforce a law that the court has ruled void. The court, in its good graces, just assumed that the federal government would comply with its ruling, but it won't. The court cannot act on its own, listening to a news report or a talk show host or reading a newspaper. It needs somebody to put something in front of him so he can make a decision. One other point. Carol Browner left Washington a week or so ago in a big hurry. Let me tell you something about Carol Browner. Carol Browner was the administrator of the Environmental Protection Agency under Bill Clinton. During the waning days of the Clinton administration, just prior to the incoming Bush administration, I and Landmark Legal Foundation, but I actually argued the case, we went into court in Washington, D.C., because the Browner EPA had not provided us with the documents and data that we had requested relating to 11th hour regulations they were trying to impose on their way out the door, because these people do not believe in elections. They do not believe in honoring the franchise. They rule in the shadows. They're despotic. The U.S. attorney representing Browner and the EPA and the Clinton administration, the assistant U.S. attorney went into court and argued, you can trust the EPA and the government. They'll do what they're supposed to do. And I argued, well, then there should be no problem. We need an order in place in case they violate it. We had a great judge, Federal District Judge Royce Lamberth. And he agreed with me. And so the order went out that the EPA is not to destroy any of its records. It is to secure those records. Then the administration left town, including Browner. And guess what? A few months later, we found out that they were destroying records on the way out the door. Emails, servers were being wiped clean. Computers went missing. Luckily, we had that order in place. And to make a long story short, we deposed 11 former top officials at the Environmental Protection Agency, including the lovely Carol Browner. And she'd claimed under oath that she never really worked on her computer. She didn't like computers. Now remember, she was a close buddy of Al Gore, the inventor of the computer and the internet, and I believe the vacuum tube. Whatever. In any event, ladies and gentlemen, I then moved to hold the Environmental Protection Agency in contempt of court for violating the court's order. And in fact, the Environmental Protection Agency was held in contempt of court. You can look it up. And they were required to change their policies. But Carol Browner, she escaped being held in contempt. The agency itself was held in contempt. Then I see what this judge just did in New Orleans, Louisiana, holding the government in contempt for violating his order, again dealing with an environmental issue, and I think to myself, well, that's kind of coincidental. Browner skipped town as fast as she possibly could. This judge held the administration in contempt. Browner was the environmental czar, if you will. Surely she had to have a finger in whatever they were doing relating to BP, the oil spill, and the judge's decision. And she skipped town. I would encourage the relevant oversight committee, that would be Chairman Fred Upton, to get your subpoena ready and drag Miss Browner back into Washington and depose her before you have her up for a hearing and question her about this whole contempt of court issue in New Orleans, Louisiana. She's up to speed on contempt. And I would also suggest that Republicans in the House, because I haven't heard them lately, in the Judiciary Committee, invite Mr. Holder, invite the Secretary of HHS to come before his committee and find out why the hell they are defying another federal judge in Florida who has ruled the law that they are illegally spending taxpayer dollars on in Washington to implement illegally, because it's a non-existent law. And get them under oath and have them explain themselves. When you are dealing with a soft tyranny, when you're dealing with rogue public officials, they need to be put in check. That's exactly what we're dealing with. Alaska Governor Sean Parnell, the Associated Press is reporting, is asking his Attorney General to advise him on whether implementing the federal health care overhaul would put the governor in violation of his oath of office. Governor Parnell, that is a very good question, and it's very wise of you to ask your Attorney General. But it's wiser if you ask me. I do think there is a question. If a governor attempts to implement a statute that a federal judge has ruled unconstitutional, whether or not it is a misappropriation of state taxpayer monies. I believe right now that you governors who were involved in this litigation, you attorneys general, you can make the case that any money that's being expended by the federal bureaucracy today to implement this unconstitutional law is fraud. It's worse than fraud, actually. But that they are not permitted to spend any money to implement an unconstitutional law.